Good morning to you. Today we are taking Union Executive, Part 5. Part 5, Union Executive. Union Executive, as you know, consists of President, Vice President, Council of Ministers, and Attorney General. This is the composition of Union Executive. Now, secondly, as I have already told you, President is part of Union Executive and Union Legislature. Why? The composition of Union Legislature is President, Lok Sabha and Rajya Sabha. That is where the parliamentary form of government is established. President being part of executive and part of legislature. So this is the first point you should remember. Secondly, instead of going article by article, I combine certain articles so that it will be easy to understand. For example, Article 52, 53, 73 and 74. These 4 articles we will take up today. Article 52 says that there shall be a President of India, which implies that there is no occasion where the President of India is absent. That is, in every occasion where there is a vacancy in the presidentship, Vice President will assume the charge of presidentship. So that is why we say there shall be a President of India. So remember, there cannot be an occasion where President is not there. This is a continuous body, number 1. Next, Article 53 says that the executive powers of the Union shall be vested in President and shall be exercised by him either directly or indirectly through his subordinates in accordance with the provisions of the Constitution. Remember, that term is very important. In accordance with the provisions of the Constitution. In addition, it has also been stated that the supreme command of all the 3 armed forces of the Union is also vested in President, and he shall exercise these powers according to law. Remember, see the difference? The executive powers of the Union shall be vested in President and shall be exercised by him either directly or indirectly through his subordinates, quote, in accordance with the provisions of the Constitution. On the other hand, the supreme command of all the 3 armed forces is also vested with the President of India, who will exercise these powers according to law. So first is in accordance with the provisions of the Constitution. Second is in accordance with the law. So the executive powers and the military powers completely separated, and one is according to the Constitution and the other is according to the law made by the Parliament, obviously. Now, this article also protects the authority of the states and the authority of Parliament. How? It is clearly stated, nothing in this article deemed to transfer to President any powers conferred on the state or any other authority. Supposing some powers are now enjoyed by the state or any other authority, this article does not transfer such powers to the President. Remember. So, the authority of the states is protected. Simultaneously, this article does not also prevent Parliament from conferring by law any function on any authority other than President. If the Parliament wants, the powers can be entrusted to other authority also other than the President. So, that is the authority of Parliament and the authority of the states have been protected from the possible, unimaginable, of course, usurpation of powers by the president. Because, you cannot imagine a situation where the President of India violates Constitution. Why? President of India can be impeached only for violation of Constitution, number one. Number two, if you take the oath of President, he is the one dignitary who takes oath to protect, preserve and defend the Constitution. See, even Chief Justice of India has no such oath. Even though Supreme Court is the custodian of Constitution, the preservation, protection and defense of the Constitution lies with the President of India. Remember, that's very important. Secondly, the executive power. We said the executive power of the Union is vested in the President of India. Now, what is executive power? The executive power used in Article 53 has been elaborated in Article 73. Remember, 52, 53, 73. What 73 says? Extent and scope of executive power of the Union. Because the executive power has not been defined clearly. What is executive power? Remember, we have legislative powers. We have judicial powers. Legislative powers have been given right from Article 79 onwards to Article 123. Legislative powers of the Union given. And 70, then take the judicial powers, 124 to 143 or 147. 124 to 147, the judicial powers have been given. Legislative powers have been given. What has not been given is the executive power. What has not, the remnant, that is the balance, that the residue is called executive powers. Colloquially, the executive powers involve determination of policy, conducting of foreign policy, implementation of law, day-to-day administration, policy making, implementation of planning. All these things are called executive powers. Now, Article 73 specifically says, what is the specific says? It says that the executive power of the Union extend to such matters on which Parliament has powers to make law and also to exercise such rights which are exercisable by virtue of any treaty or agreement. So here it is very clear. That is, President of India enjoys executive powers in respect of matters on which Union Parliament is competent to make law. Where is it given? Schedule 7. Schedule 7 gives you the Union list, state list and concurrent list. Union list say 100 subjects on which Parliament is competent to make law. State legislatures are competent to make law on state list, 66, now 61. And concurrent list, 52, 47, now 52. So, 3 lists are there. So, Parliament can make law on Union list and concurrent list. State legislatures can make law on state list and concurrent list. If there is a clash between a Union law and state law in respect of a concurrent subject, the Union law will prevail over the state law unless the state law has been reserved for consideration by President and President has given the consent. If President has given the consent to a state bill, that will prevail over the Union law. Remember, why? Because President is part of Parliament. If President has given the consent, that means Parliament has given the consent. That is why. So, this list has been given in the Schedule 7. In other words, executive power of the Union is coterminous with the legislative powers of the Union. Remember. And in addition, the powers as authorized by any treaty or agreement or synod made with other countries, those powers are also with the President of India. So remember Article 73. Does it imply that the President has got only executive powers? No. Every function, even judicial function, some functions are appointment of judges. It is executive function. And the legislative function. Because when he acts as a legislative head, he is a part of legislature. Why bills are recommended by him? Because he is part of legislature. So he exercises all the functions, executive function, legislative function, judicial functions, etc. That we will see when we deal with Article 74. Now, how the executive powers are exercised? That is the next point. Kindly recall, what did I say? Under Article 53, the executive powers of the Union are vested in President of India, who shall exercise these powers either directly or indirectly through his subordinates in accordance with the provisions of the Constitution. Now, in accordance with the provisions of the Constitution, you should read with reference to Article 74. Remember, Article 74. You have to see Article 53 vis-a-vis Article 74. What does Article 74 says? There shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President of India, who shall, underline shall, in exercise of these functions, act according to such advice. Remember, according to such advice, by stating, in exercise of these functions, it has been made clear that the President is bound to act in respect of all functions, whether be executive, whether be legislature, whether be judicial, all functions. Remember, the point you should ponder over is 42nd Amendment Act 1976 made it obligatory for the President of India to act as per the advice of Council of Ministers. Shall has been added. Who shall? That shall was added by Mrs. Gandhi's government through 42nd Amendment Act 1976. So remember, at that time, after addition of shall, the President has no option at all. He has to act according to the advice tendered by the Council of Ministers. Why? Because he is the defender of the Constitution. He cannot violate the Constitution. So, he has to act according to the advice tendered by the Council of Ministers. Nevertheless, 44th Amendment Act 1978 gave a option to the President. In case of disagreement with the advice tendered by the Council of Ministers, the President can refer back any such advice to Council of Ministers for reconsideration. Remember, if any such advice is reconsidered and tendered again, the same advice by Council of Ministers, the President of India is bound to act according to such reconsidered advice. Remember, the only option open to the President is to refer back any advice to Council of Ministers for reconsideration, and in the event of such advice being reconsidered and tendered again, President of India is bound by the reconsidered advice. Okay, this is called 44th Amendment Act, the only option open to the President. Remember, most importantly, the question whether any advice was given by the Council of Ministers, and if so, what is the nature of advice, cannot be questioned in any court of law. A judicial immunity given to all cabinet decisions. Court cannot go into the question of whether any advice has been given by the Council of Ministers. If so, what is the nature of advice? Remember, except, underline, except. In respect of Article 356, when imposing precedent rule, Supreme Court has ordered it is subject to judicial review. That is, the matters, the circumstances under which the president rule was imposed on a state should be disclosed to Supreme Court. That is the only exception where the cabinet decision is revealed to Supreme Court or High Court. So this is the only exception, remember. You may recall, in October 1997, Cabinet recommended President rule in Uttar Pradesh, Kalyan Singh government, and it came to K.R. Narayanan. K.R. Narayanan referred the advice back to the Council of Ministers for reconsideration. Better sense prevailed and they shelved the idea of imposing President rule on UP, and the Kalyan Singh government was saved. This is one instance where the advice was referred and the government reconciled. Another advice, in September 98, K.R. Narayanan returned the advice for imposing President rule on Bihar. However, after 5 months, the Union of India reiterated the same advice again, and President of India imposed President rule in, I think, February 1999. After 5 months, it was imposed. So these are all the two clear instances where the President of India referred the advice back to Council of Ministers, and Council of Ministers reconsidered, tendered again. So these are all the two specific instances. Next, the Article 74 says there shall be a Council of Ministers headed by the Prime Minister. Headed by the Prime Minister. What does it mean? That means there shall be a Council of Ministers. Without Council of Ministers at the center, there cannot be a situation. Even if the ministry fell, the so-called caretaker government will continue. Remember, there is no caretaker government provision in the Constitution. Caretaker is conventional. When you are shifting your house from one house to another house, you will not undertake major repairs. Suppose, let us say, you are in a rented building. You have decided to shift this. Or in your own building, you have decided to sell the house. You will not undertake any major repairs, major construction or reconstruction or modification, because you are going to shift to some other place. So now, in the same analogy, a government which has been defeated on the floor of the house, or a government which is not able to run the ministry, in that case, it is not supposed to take any major decision. So there is no provision for caretaker government. In fact, Charan Singh government was 4 months, it was a caretaker government. So there is no provision for caretaker government in the Constitution. Nevertheless, it may be necessary. In fact, Kargil episode occurred during caretaker prime ministership of Atal Bihari Vajpayee. So there is no question of caretaker government. Every government is full-fledged government. Even if it is defeated on the floor of the house, the convention is that they will not take any major decision. So this is there shall be a Council of Ministers to aid and advise the President of India. That Council of Ministers is headed by the Prime Minister. What does it imply? Another point you should remember, without the Prime Minister, any number of ministers is not a Council of Ministers. Without the Prime Minister, any number of ministers, 80 ministers, okay, 15% of the Lok Sabha, 80 ministers are there. Prime Minister is not there. It is not a Council of Ministers, remember. But Prime Minister plus one Cabinet Minister constitute Council of Ministers. What is the rationale of one Cabinet Minister? 44th Amendment Act added the Cabinet advice of all the ministers of the Cabinet rank for imposing national emergency. So, one Prime Minister plus one Cabinet Minister constitute Council of Ministers. Instead, any number of ministers without Prime Minister is not a Council of Ministers. Another point, a resignation by a single minister creates only a vacancy, whereas resignation by the Prime Minister dissolves Council of Ministers. So, Prime Minister is not only first among the equal, he is the pivotal of cabinet form of government. In fact, a powerful Prime Minister is the prime ministerial government. There is no need for the presidentship. It is the prime ministerial government who is all powerful, whether it is legislature, whether it is judicial, whether it is executive. All powers are concentrated on a prime minister who has 2/3 majority in the parliament or 3/4 majority in the parliament. So this is the one point you should remember. Another second point you should remember is Article 74 uses the term Council of Ministers. Remember, Council of Ministers, maybe 80 ministers will be there. It is a composition. Council of Ministers. Remember this examination point of view. The portfolio system allocating the ministries to various ministers itself originated Lord Canning. It is a Canning. The portfolio system was introduced by Lord Canning. And the Council of Ministers is the real executive, remember, by convention in UK and by codification in India. India, it is codified. It is the full-fledged real executive powers are vested with the Council of Ministers only. However, there is another term called cabinet. The term cabinet, as I said, has crept in through 44th Amendment Act 1978 as an amendment to the Article 352. In 74, Article 74, there is no mention about the cabinet. Cabinet is nothing but a small body of senior ministers to give advice to the Prime Minister, to look after the day-to-day administration, all the policy decisions, everything is done by the cabinet only. All decisions are taken by the cabinet and they are formally approved by the Council of Ministers once in a month or once in 2 months. So, Council of Ministers has become weak. Cabinet has become strong. So, even though cabinet has no what is called recognition in the Constitution, Constitution recognizes only Council of Ministers. There is no mention of cabinet in the Article 74. But in practice, cabinet is the actual Council of Ministers on which the entire government of India runs. Remember. Second point you should remember. Thirdly, remember, when we talk of Council of Ministers, there is a five-tier system. Five-tier system. What is that five-tier? Number one, cabinet ministers, which I have already told you, a small body of the ministers, senior ministers, looking after various portfolios, and they are responsible for taking decision on whom the entire government of India runs for all weather, and these ministers are consulted by the Prime Minister. This is the cabinet small team. Secondly, minister state independent charge. Remember, independent is only for administrative purpose. For all policy decisions, Minister of State, independent charge, dependent on the Prime Minister. Remember, under the system, portfolio system, whatever departments not allocated to the ministers belong to the Prime Minister. Whatever departments not allocated to the ministers belong to the Prime Minister. So, the Minister of State independent charge is looking after health ministry. So, for all policy matters, that health ministry, MOS health is responsible, MOS independent charge health is responsible to the Prime Minister for policy. For day-to-day administration, control of officers, writing CRs, allocation of business, allocation of funds, etc. He is the Minister of State, independent charge is responsible. The third tier is mere independent charge. That is, mere MOS, Minister of State, non-independent charge. They are responsible to their cabinet minister. The cabinet minister under whom Minister of State functions, he will allocate the business to the MOS with or without the approval of the Prime Minister or Prime Minister's office. So, 3 tier. Fourth tier is Deputy Minister. Deputy Minister is normally a minister under Cabinet Minister to assist parliamentary work of the Cabinet Minister. In addition to the 4th tier, there is one more tier called Parliamentary Secretaries. Remember, Parliamentary Secretaries after 1997, there is no Parliamentary Secretary. Pramod Mahajan was Parliamentary Secretary. M.L. Fatedar was parliamentary secretary. So this has been discontinued according to my knowledge. It is 1997. After that, there is no parliamentary secretary. One important factor you should remember is these parliamentary secretaries are administered oath of office by the Prime Minister. Remember, not by the President, by the Prime Minister, as in the case of Deputy Chairman Planning Commission, or now as in the case of Vice Chairman Niti Aayog. In both the cases, Prime Minister will administer oath of office and not the President of India. In the same analogy, parliamentary secretaries are administered oath of office by the Prime Minister and not by the President of India. Secondly, parliamentary secretaries are not expected to attend cabinet meetings. Cabinet meeting, they are not expected to attend. In the states, the parliamentary secretaries are discouraged as per the Delhi High Court. As you know, the Delhi government appointment of parliamentary secretary. The court did not agree with them. So, this is the position of parliamentary secretary. Now, I told you that the Council of Ministers' advice is binding on the President, and the President can refer back any advice tendered by the Council of Ministers for reconsideration, and in the event of the advice being reconsidered and tendered again, the President of India is bound to act according to the reconsidered advice. I told you, this is the only option available. So, in nutshell, you remember, the President of India cannot act without the advice of Council of Ministers, nor can he act contrary to the advice of the Council of Ministers. All functions, except, remember, every function of Government of India, President is to act according to the Council of Ministers' advice. There is no other, except one. Remember, except one. Under Article 103 of the Constitution, if a question of disqualification of Article 102, Clause 1, is referred to the President of India, then the President of India will refer this to the Election Commission, and the Election Commission's advice will be coming, and he will act according to the opinion of the Election Commission. On that occasion, President of India will not be bound by the advice of the Council of Ministers, because the Council of Ministers is irrelevant. Jaya Bachchan case, disqualification under Article 103. President is bound by the advice tendered by the, not advice, it's opinion. Advice is Supreme Court. Opinion tendered by the Election Commission. In that case, President is bound to act, not Council of Ministers. And in all other cases, unconventionally, conventionally, President has certain discretion. For instance, if there is a fractured verdict, appointment of Prime Minister, or the Prime Minister has lost the mandate on the floor of the House and re-electing. Remember, in our country, the Prime Minister is first selected by the party. Appointment comes subsequently. So, selection first, appointment second. So, this we will discuss in Article 75 of the Constitution when we take up in the next class. Thank you very much. Study well. Thank you.